Good evening. Welcome back to this supersized edition of All In. The Trump administration has been defying court orders in a way that's sort of frustratingly amorphous, but right on the precipice of just a full-blown constitutional crisis. Well, today, a federal court responded to the administration taking the boldest step yet to knock down their illegal renditioning scheme under the guise of the Alien Enemies Act of 1798. Now, that law has only ever been invoked in times of war, real war. I mean, we're talking the War of 1812, World War I, and World War II. So to justify using it, the Trump administration claims basically that we are in a situation like those three wars, that we are actively at war with a Venezuelan gang called Tren de Aragua, which, and this is key, the administration falsely claims is an arm of President Nicolas Maduro's Venezuelan regime in that country, despite their own internal intelligence insisting otherwise. Now, just to state the obvious, we're not at war in any sense of the word that we understand it legally with this gang or Venezuela. I mean, everyone knows that, right? Like if you walked up to people on the street and asked them. But the Trump administration likes to use just almost apocalyptic language to imply otherwise.
If I offered any one of you a rent-free home with no taxes to pay in any of these gang neighborhoods, and I said your neighbors are MS-13 terrorists or Mexican mafia or Sinaloa cartel or Tren de Aragua, I couldn't pay you to live there. But yet you, with your coverage, are trying to force innocent Americans to have these people as their neighbors, and that one day their daughter may be abducted from their home and raped and murdered. So you're not going to get an ounce of sympathy from this administration or President Trump for the terrorists who've invaded our homes and our country.
Okay, so today, following a lawsuit from the ACLU, a federal judge finally called the administration's bluff and basically rejected the fundamental premise of their actions, at least when it comes to the question of the Alien Enemies Act. In a 36-page ruling, a district judge in Texas named Fernando Rodriguez Jr. told the White House in really no uncertain terms it cannot use the Alien Enemies Act as justification for these renditions, at least when it comes to Venezuelan detainees in his southern district of Texas. Quote, the court concludes that as a matter of law, the executive branch cannot rely on the Alien Enemies Act based on the proclamation to detain the named petitioners in the certified class or to remove them from the country. Judge Rodriguez, in his opinion, goes on to call BS, basically, on the White House's argument. Quote, the historical record renders clear the president's invocation of the Alien Enemies Act through the proclamation exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms. Adding, as for the activities of the Venezuela-directed Tren de Aragua in the United States and as described in the proclamation, the court concludes that they do not fall within the plain, ordinary meaning of invasion or predatory incursion for the purposes of the Alien Enemies Act. In other words, no, we are not at war with Venezuela or a Venezuelan gang, and they are obviously twisting the meaning of the 1798 statute Alien Enemies Act beyond all recognition to the point where, according to the judge, they are now banned permanently from using it as justification for their renditioning scheme in his district, at least while this ruling stands. By the way, interesting note here. This judge in question, Fernando Rodriguez Jr., is not some liberal activist. He was appointed to the bench by, drumroll please, Donald Trump in 2017. Now, the administration will almost assuredly appeal. The big question is if they will even attempt to obey the order in the meantime, or, and this is really high stakes, if they will once again openly defy the courts. After all, the administration's not exactly subtle about their willingness to just try to run over the independent judiciary.
I mean, it turns out we've got to do some battle with some really crazy far-left judges in order to allow the administration to do what it actually needs to do. And I will say, to great credit, the president expected this. When we came in, he said, we're going to start deporting people, and a lot of these far-left judges are going to stop us, and there's no way out of it but through it. And we're just going to have to battle. We're going to have to win the court cases. We're going to have to take some of this stuff all the way to the Supreme Court, and we're going to have to find alternative ways to deport people when the judges say you can't do this method. We're going to have to find another method. So we recognize that we're doing battle with basically a massive bureaucracy that has decided that it rules the country rather than the American people.
Again, the far left judges that Vance is talking about, that's on Tuesday, in this case is a Trump-appointed judge. And it appears as part of the battling that the administration is doing has been just ignoring court orders. I mean, right now, the administration is still refusing to facilitate the return of Kilmar Abrego Garcia from her prison in El Salvador, even after the Supreme Court unanimously affirmed that it must do so. We have seen time after time their strategy is to deport these folks before the courts have time to intervene. Now, sometimes they deport them even after the courts have intervened and instructed them to turn the planes around. But sometimes they don't move quite quickly enough. A couple of weeks ago, we were covering this live on the air, actually, because it was happening in our hour, when an 11th hour appeal from the ACLU and a subsequent ruling from the Supreme Court stopped the removal of a bus full of would-be deportees to El Salvador and Venezuela. Those men are now stuck in limbo in a Texas detention facility. Yesterday, they put together this really remarkable signal to the outside world, spelling out SOS with their bodies in protest of their potential impending removal to a foreign gulag. Reuters actually managed to speak to one of those men, a 19-year-old named Jefferson Escalona. Now, the Trump administration insists that Escalona is a self-admitted member of Tren de Aragua, although it has not issued any evidence to support that claim. Now, Escalona insists he is not a gang member. He says, in fact, he was a police officer in Venezuela, and that the Trump administration's evidence against him appears to be photos of him making hand gestures they found on his phone. Escalona fears that he will be sent to that notorious prison in El Salvador. Again, the future of any Alien Enemies Act deportation seems uncertain, but at least for right now, one of Trump's own judges is saying absolutely not. Lee Gelernt is the lead lawyer on this case. He's the deputy director of the ACLU Immigrant Rights Project, and he joins me now. Lee, let's start with this ruling by this Texas district judge. What do you make of it?
I think this is a huge first step. Chris, you hit it on the head. Two themes that you and I have talked about for years are involved in this case. The first is that the Trump administration walked into court and said, we will tell you what the law is. You, the federal judge, don't have a role to play in telling us what the law means, what this congressional statute means. The judge said, no. I'm the federal judge. I will tell you what the law means. That's my job. That's critical that the judge put his foot down and said, you do not get to decide, you, the executive branch, don't get to decide what the law means and then carry it out. The second thing he did is say, look, this is a law Congress passed, and these are critical separation of powers issues. The executive branch can't just thumb their nose at what Congress is doing. Congress put very specific guidelines in, and as you pointed out, it says we have to be at war or being invaded by a foreign country or threatened. The judge said under no circumstances are we being invaded by this criminal gang, and said now you cannot use this law again. As you said, they're going to appeal, but this is a critical first step in what's going to be a long battle. But we hope that the courts will ultimately affirm this.
Yeah, I mean, this is going to be appealed to the notoriously right-wing Fifth Circuit, which is the circuit there, which is based out of New Orleans and covers Texas. It'll, I think, end up probably before the Supreme Court. But the other aspect here is the current hold on moving people, which seems so essential here because we've seen what's happened when they're allowed to do it, which is they flew the planes, they kind of thumbed their nose, and now you've got these individuals there, including someone they admit was mistakenly sent there, Kilmar Abrego Garcia. You've got others who I think have pretty strong cases. They're just cases of mistaken identity, like they're not gang members and they're there, no way out. What is the status of this prohibition right now on sending people there? Because it's quite confusing given the kind of patchwork.
Yeah, you're exactly right to bring up that issue. So this is what's happening. The Supreme Court said you can't do one case. We had originally brought it as one nationwide case in D.C. Supreme Court said, no, you have to do it in what's called habeas corpus petitions in the district where people are detained. So what's happened is the administration is moving people from district to district all over the country, forcing us at the middle of the night sometimes to have to keep filing habeas petitions. So now this judge said you cannot use this act and you cannot transfer people out of the Southern District of Texas. We have an injunction in Colorado, in Pennsylvania, in New York, but we know the administration is going to try and evade judicial review by constantly moving people around. So what we've told people is, if you think that one of your clients is at risk somewhere in the country, we will file something in that part of the country. And we're just going to have to keep doing it until ultimately the Supreme Court steps in and issues a ruling one way or the other. But that's the problem, is rather than the administration saying, OK, well, we'll be orderly and wait for a court ruling, they're just moving people around and trying to do it without us noticing.
So I don't know off the top of my head if Department of Homeland Security has said something one way or the other, in the interest of fairness here, about whether they're moving people intentionally for that purpose. But what you're saying is you think they are intentionally moving people through jurisdictions in a game of sort of like staying one step ahead of habeas petitions, with the possibility of maybe getting people onto planes they can send down to El Salvador?
You know, I obviously don't know exactly what their mindset is, but it sure seems that way. And so note that all the people who were sent to the Salvadoran prison on March 15th were from the Southern District of Texas. We now have an injunction there. Right. So they've started putting people in the Northern District of Texas. We know that our clients in Pennsylvania, Colorado, other places have been moved to Texas. And so, you know, the administration can say that's not why we're doing it, but it feels like that's what they're doing, and it makes it very, very difficult. But what we've said is we will file as many as we have to.